I may be please your lordship. Matter with the raising the senior most is there. Why, sir, mentioning the seniors are not supposed to mention, sir. Seniors paradise.
The situation is like this, my lords.
Tell your junior to come.
My lords, next time I will definitely.
Pass on the memo,
But
please. Pass on all the memos. Pass on all the memos.
First PL.
Pass on, don't worry.
Lord,
Let's end the matter. Let's make it.
Mr. Gulati is on VC for item 33.
my lord, I just heard your lordships that seniors are not supposed to mention, but I wanted to make a personal request, my lord. That is
What?
why I'm mentioning.
Yes, now. VC has
Uh,
gone. Now it has come. Yes.
My lord, I wanted to make a request, my lord, in item 33. My lord, this is a matter which is, my lord, pleadings are complete and it's an important issue. I wanted to come, my lord, physically to argue this. May I request for a specific date, my lord, where in August, where your lordships can take it up and my lord hear it?
Who is for the other side?
State and Union. State and Union, your lordship.
But he must be representing the state, sir. I just wanted a name.
Mr.
For the other side.
Mr. Satpathy, TK Satpathy, sir.
Please inform whether he is agreeable. Talk to him.
What?
Whatever the date is suitable to both of you, just convey.
Yes, ma'am. I'm deeply obliged. Deeply obliged.
Item 26, my lord. Item 26, I have filed an interim application for withdrawal of writ application. That is 26.
For the other side, sir.
Other side is Mr. Tripathi. I have already.
Please bring him so that at least his name should go there. Bring him.
Item number 1.
Item number 1, my lord, I'm praying that item may be taken any other day, my lord.
Why?
This transfer brief just before a day before yesterday we received the brief. I have not.
Why?
Well, I need further preparation, my lord.
Why you received the brief yesterday?
Day before yesterday we just and
I have some reservations on that. Yes.
I'm extremely sorry, my lord.
If you have accepted a brief, knowing fully well that the matter is tomorrow, listed tomorrow, then you should be ready with it.
Sorry, my lord. I'm extremely.
That ground is not a good ground.
Pass it over.
That is not a good ground.
I'm sorry. I'm extremely sorry.
No, not sorry. What for?
But it's a PIL in service matter.
PIL, say upon non-appointment of tutor or instructor who working at private institution to avail the benefit to appoint as assistant professor lecturer, even though they have got more experience than who were working in government. But
there must be a rules which is framed for that.
That rules I
appointment of the assistant professors, the assistant lecturers. There must be a rules framed by the government for recruitment. Is there any recruitment rules? Nobody knows.
Even though GNM work there, they avail the benefit.
Any appointment to a particular post in a government organizations must be guided by a rules.
But I'll take instruction, my lord.
You do not know. Then who drafted it? When you draft it, will you not first thing you will ask that is there any rule? Is there any barrier which is put there?
Our only grievances
you are arguing so far as Article 14 and 16 is concerned. Will you not do it?
Annexure 4 is the rule. Annexure 4 is the rule.
Is the rule?
Yes. Page 33.
Yes, that is the rule. You don't know.
That's why I have not gone through the documents properly. Annexure. That's why I'm seeking time, my lord.
Anyhow, I am not imposing my personal views on that. This is up to you.
This is my first time asking time. I'm extremely sorry.
Anyhow. Yes. When When
Well, let's say we fix any day. Okay, any day.
any day includes today.
Any day excluding today.
Keep it after 2 weeks.
Item number 2.
Your Lordship, the Tahsildar was supposed to give us instructions on whether the Jagannath temple is situated upon the land that is Gotra land or not, Your Lordship. He had contacted the Tahsildar, he had asked him to see the records, he's verifying the records, 2 more days time, giving him Wednesday, Your Lordship. On Wednesday.
He has taken 2 times, my lord.
Say, Lordship, but I have spoken to him personally, he's looking.
Not 2, 3.
My lord, 3 years.
Yes.
On Wednesday, it will be.
Yes, what do you say?
My lord, my prayer,
What
submission
did you
is
say about her prayer
my lord, short dead, man.
after a week?
Item number 3.
Your Lordship, there is an application similar to the batch of matters pending before Your Lordship concerning the challenge to the excise policy of 2025, thereby imposing restriction on restaurant licenses on
The
shop.
Advocate General has been noticed. You are challenging the virus.
Your Lordship. Lordship, in a batch of matters, Your Lordship, it has been done, Your Lordship. Earlier, Your Lordship.
I
A similar-
understand 180 ml concept.
Your Lordship,
but I know, but in this matter, the Advocate General has to be given a notice. Give a notice to the Advocate General because they have challenged the virus of the particular provision of the this.
This land went for the construction of a bus
What is
stand.
that land?
OSRTC, Odisha State Transport Corporation
Yes.
land of Annex 1.
Yes.
That is being encroached by the private opposite pattern number 7 to 11.
It is not Odisha Transport Corporation land. The ROR seems to be in the name of Commerce and Transport Department.
Yes, ma'am.
That is
Transport
something different than
is a transport.
OSRTC.
That is Transport Department.
Please, sir.
Odisha Road Transport Department. That is.
Odisha Road Transport Department is not there. It is
Transport
Commerce and Transport Department.
Transport Department.
Ah.
That is the Annexure 1.
Ah.
Then that has been pursuant to this Annexure 1. Annexure 4 series, the eviction notice has been
Not
issued.
very rigid,
Eviction.
Mr. Counsel. But anyhow, if it land belongs to the government or a department, then encroachment, you have to take care.
But my lord, there is already an order at page 54. Your Lordship may kindly see. Earlier, I think they had approached this honorable court.
No. That is the citation I have given the previously. The honorable court by Annexure 6. 6 has passed and some stipulations directing the state authorities to remove the encroachment. That is I have annexed. That is the order of this in another case.
Then I'll have to take instruction. I'll take instruction. 2 weeks time.
2 weeks.
Item number 5.
That's I'm for the petitioner. I seek 1 week's time to place 2 documents on record through an affidavit, which is very important in this. It's a tender matter.
Important.
Because just to prove my case, these 2 documents are required to be placed on record.
Why you did not annex with the writ petition?
My lord, it was inadvertently missed. So it may come next week on Tuesday or Wednesday.
Do it 2 weeks, sir. Yes.
Item number 6.
This is your lordship. But this is the matter where Last occasion, my lords, this is regarding that change of criteria, financial criteria from 10 crores to 50 crores for the same work. And your lordships had also posed the question that if they have the prerogative irrespective of the amount. There's a judgment of this Honorable Court of the Division Bench, which I could locate, my lords, and data.
On the test of reasonability.
Yes, my lords. Whether it has a connection or the criteria has the connection with the aim to be achieved. There, my
That
lord,
is the test of reasonability.
reasonable. There, my lord, it was an issue where for 200% supply, they had fixed the criteria at 10,000 manpower should have the capacity.
What do you say, sir?
My lord,
If there is already a decision of the
Ma'am.
division bench,
Ma'am.
then
we have to verify.
it's binding on us,
Ma'am.
unless we take a dissenting view.
Obviously, that's
My lord, I have to verify
because
this.
in the meantime,
What
my lord,
My lord, my learned senior is in
My
VC.
lord, I'm sorry, my lord. It is a case. It is a case where we have the allegation is against us that we have imposed 50 lakhs surety.
50
The person working and we have extended admitted we have extended some period because the new tender has not been floated. So in the 3% has been participated in the tender. He didn't object. He is well known to him that he has been extended. His period will complete by 30th. A new selected candidate tender bidder has come to force, and they have deployed. They are working. They are working in this place, and they are not working in this place.
No
and
question.
Supposed to, my lord.
Mr. DSG, the question is not that whether they will continue working or they will not continue working.
Yes,
or some continuing with the working. Question is that once you enhance the barrier from 10 crores to 50 crore,
my
it
lord.
must achieve the purpose for which it has been enhanced. If the purpose is, as it appears, the hidden purpose is to exclude certain other eligible candidates to participate in the process, then the question has to be tested.
I'm just clarifying for a moment.
What is the rational between 10 crores to 50 crore?
No, and in April,
that I'm clarifying just now. That I'm clarifying just now, my lord.
In May, they bring it to 50.
Rational.
Absolutely
Yes,
nothing.
yes. That I'm clarifying. That I'm clarifying for a moment. I'm clarifying. My lord, this previous tender, we are engaging a 50 to 60%. Now, lot of project has been taken by this management because there is a sponsorship working. They are paying the rent to the different structures. They are paying the salary from this by joint venturing of all this process. So they have expanding. They have take up the recently. They are going to take up the ITC projects also. They are going to make a new projects for which they only employed more than 100 or 150 like this, what they are saying, and simultaneously gradually it increased to 500. So the person who was participated and given the persons for deployment, they must have that much of capacity to provide all these things. That's why there are three bidders, but it is not that a single bidder hasn't participated.
Then you'll have to show that what is a policy decision. There must be a discussion. There must be something which
we have ready with an affidavit. Let's say I'm served it to my learned friend. Let them go through it. Let's see, take it Tuesday or Wednesday.
They have not given anything.
What you have served?
We have ready with an affidavit. Today will serve to him. Yesterday it was this principal has come and I finally
counter or what?
My counter. We are ready with the counter.
We have got a preliminary counter for the same, and we are filing today.
Will also verify.
Then let them. We will serve the copy also. Take Monday or Tuesday. No issue. Because already it has finalized. 3 tenders been participated, and who is a successor bidder who have given that. Lordship is raised a very pertinent question. Whether it must be rational.
Assuming
Please, your lords. But here, my lord, I have challenged the finalization of tender in favor of opposite part number 4, my lord, without following the tender conditions and without conducting the lottery as required under the tender application, my lord. My lord, initially application was invited by under Annexure 1 for development of, and that was under Annexure 5, that they said that the following tender work will be drawn on, lottery will be drawn on 8/5/2025. Thereafter, it was again by under Annexure C, the 6, my lord, they further extended the time limit. And Annexure 6, my lord, page 19 also the same, they further it extended. All of it sudden, my lord, without any notice, they finalized the tender on 10/6/2025 in favor of opposite partner 4, that is under Annexure 7, my lord. Without any notice, without any previous intimation to all the bidders. Though I was shortlisted.
Was it opened on the extended date?
No, my lord. It was extended from time to time, and last extension was not communicated.
Was it extended? What was it opened on 20th May?
No, my lord. No, my lord.
You had a notice of this?
My lord, yes, they issued a notice that the.
So you knew it that it is going to be opened on 20th?
I was issued notice indicating that the opening date is postponed.
No, this is you are relying on this annexure 6, which says that the tender would now be finalized or opened on 20th.
20th 5/2025.
Correct.
Annexure 6, your lordship,
Correct.
referring to.
So it is all, you knew it that it is going to be opened on 20th of May?
Yes, my lord, I knew it.
So
thereafter, they further extended it.
Where is that extension?
Page 19, your lordship.
Where is the extension?
Page 19, your lordship.
For 8th May.
With
No,
reference.
that was earlier, 8th
Yes.
May.
Yes,
it was extended to 20th May.
Yes, my lord.
So 20th May, that letter was there. 6/2025, you are
Yes, my lord.
corrected.
Yes, my lord.
So that means there must be an opening of the tenders. The tabulation is done that who has
Yes, ma'am.
quoted this. Then the committee sat and took a decision later on. It may be.
But on 25 to
Only thing
25,
is,
it was not
opened
opened.
on 20th in your presence or not opened on 20th?
It was not opened on 20th.
Have you, where you have stated on oath?
Yes, ma'am, that I have stated.
Please, where? Show us. Where you have stated that you were there on 20th of May, they did not open the tender on that day. Where is that? I could not find from the petition. That's the ground.
Yes, ma'am.
So you have not.
But on 25 to
Sir, you
25.
say that they finalized on 10/6, but did you remain present on 20th? You have to say that I was there.
Yes,
In my presence, opening of the tender would be done. It was not done.
My humble submission, my lord, on 20th 5/2025.
You have not said anything.
I will file an affidavit with your lordship, DJS, my lord, because that is the date, my lord, on which it was not filed.
You have to absolutely a defective petition, but still the question is that if you have fixed a date for opening, did you open the tender on that?
Yes, my lords. My lords, that to that effect, I'll take instruction, my lords. But in this case, my lords, work order has already been issued, my lords, and
If the illegality is projected before us simply because some cherry picking has been given a work order, that means the court will be a mute spectator, will close the file, and then will not pass any. Then there is no point of the constitutional creation of a judiciary.
let's do that.
Show us immediately that your conduct in this particular the entire exercise was above board. There is no suspicion. Show us.
My lord, take instruction whether on that said date in the presence of all the bidders, whether the lot.
Whether it was opened on 20th of May, if it was not, whether the time was further extended, if extended, whether all the participants have been duly notified, all these things you'll have to do.
Yes, my lord.
Proceeding on that page. Proceeding, recorded proceeding. Get the proceeding
Yes, my lord.
File affidavit.
on the
Yes,
on
I'll file
the
an
very day when the bid was opened in presence
Only
of
will
all
grant you the
bidders.
register to file an amendment.
You might have taken
the
decision
application
later.
for amendment of the resolution.
my lord.
How soon? How soon? In advance.
Yes, my lord. There is an application for
And in
interim.
the meantime, take instruction.
Yes,
There is an interim prayer, my lord. But there is an interim application.
On this pleading,
I am sorry, my lord.
the greatest of injustice if it is done.
I am
Greatest
sorry.
of injustice if it is done. You have not made out a real case.
I am sorry, my lord. It escaped my
It's
lord.
not a sorry, but
Yeah, my lord, I don't.
so these are the very basic,
Yes,
the feature of a pleading. You are arguing the point which is not there in the pleading. How can court? PIR 1994 Supreme Court. There is a judgment where the Supreme Court has deprecated the interim order to be passed on a oral submissions when there is no pleading.
I'll check.
Yes.
Item number 8. This is a matter similar to the item number 3, my lord. 180 ml IMFL. Within your lordship that put advocate general.
No copy. 180 ml.
Yes.
Item 9.
Please.
Deputy.
May it please your lordships. But I'm challenging the demand cum show cause notice which has been issued for imputing tax liability for a works contract which was entered into before the implementation of the GST. And the work has been completed after the implementation of GST. And
Please already in order.
my contention is that
The work order prior to the GST. There is already one order which has been passed by us.
My lord.
It is a judgment, Your Lordship, but my Lord Justice, Honorable Justice Raman is the party. Similar circumstances, similar SOCOS notice has been challenged, Your Lordship. Similar
SOCOS
work
notice. SOCOS notice.
Your Lordship. Similar reimbursement, GST reimbursement differential, Munapani case.
Acha.
No, subsequent there too also there is one.
It is the identical circumstances, for that reason I have cited.
Have that revised guidelines.
Your Lordship,
My lord.
According to revised guidelines, it has to be computed.
my Lord.
My lord.
That virus was challenged and virus was upheld.
That case,
And
Harish.
judgment.
My lord, the guidelines dated 10/12/2000.
Ma Vaishno Devi, Harish Maj.
Harish Maj.
Your Lordship.
that is referred to here.
Your Lordship.
After revision also, there was another challenge.
My Lord.
So that was also dismissed.
Your Lordship.
Thereafter, you have given him the notice for
Your Lordship.
proceeding.
Your Lordship.
So this judgment has come.
Your Lordship. Exactly.
I believe that we have also passed an order in that effect. I know. Yes.
My limited
sorry,
prayer is, my lord, I may be given a
You are
opportunity.
for the authority to
My
substantiate your claim.
lord, I may be given opportunity to submit a comprehensive representation, my lord, before the authority.
Your Lordship.
Spend the time.
Your Lordship, it is a demand come
No,
show cause notice.
there is
He has not
time.
given a reply. So
My
let
lord,
him
we have-
reply to the show cause notice.
We
Your
have, my lord, submitted our reply.
Yeah.
Given.
Yeah, Lordship.
Necessity also 37 2024 order.
1 hour.
No, it's a show cause
37
notice. Your Lord.
2024.
Focus now.
Demand come
Nearly
show
1
cause
year
notice.
Elapsed.
practically.
Yeah, Lord.
Is another lease of life.
My
I
lord.
wanted.
Yeah, Lord.
Give a fresh air.
It has not been concluded.
No,
No,
Lord.
my lord.
No, nothing.
He has not given any reply till now. It's not been concluded.
My lord, we
Not
have
concluded.
submitted our written replies, but no instruction as to or no response has been granted. The proceedings
You
are.
want
I have to, Your
comprehensive
Lordship, I have to
reply,
verify
give,
whether
then you give.
My lord.
I have to verify whether the order has been
Please-
passed or not. Your
Please verify it so that we can extend
Yeah,
the
Lord.
time. You verify just for this purpose. Come on Monday,
Yeah, Lord.
My lord.
take instruction and give.
Obligation.
Yes.
Item 16. May it please, Milats. Plus, the seminal issue that arises in this petition, Milats, is whether the shipping bills of iron ore fines, Milats, should be assessed on wet metric ton basis or dry metric ton basis. Now, that issue, Milats, stands covered by the judgment of the Honorable Supreme Court in the case of Milats. Give a copy of that.
Gangadhar Nursing.
Yes, yes. Union of
And it-
India
but,
versus.
Here, Milord, the issue is pending before the authority, and he is seeking for direction to dispose of the
I
matter.
could see from his petition.
Yes.
Yeah.
Where he wanted to rely upon that.
But
Nursing the
proceeding has not yet been completed, whether it be WAT or MT, it has not yet been completed. So cause notice has been issued, and there is a time limit for some time, 1 year. But thereafter, further so cause notice issued. I have taken instruction that 11 parties are there. So, your Lordship may dispose direction 3 months. It can be disposed of. The proceeding.
Proceeding, and then you'll have to deal with all those points.
Yes, Milas, they indicate
That
they
is
have
that is as to be
they have to because Milas, the anxiety, Milas, is this: the show cause notice is premeditated, and it says it has to be decided on dry metric ton basis, which is directly opposite what this nursing das judgment says. So therefore, Milas, let them consider these judgments.
Explain that.
Yes, we'll explain.
The reply.
Only thing, because it is
there, they are just sitting over the matter. Proceeding
and there was an earlier direction of this honorable court also that they have to dispose of by 10th of May 2021.
What are you doing?
No, Milord, the provision is not there. This is not the only party. The 11 parties are there. Some are responding the notice, some are not. Thereafter, Milord is seeking permission from the commission.
In one show cause, 11 parties.
These
All
Milord,
concerning the same issue.
same issues, Milord, same issues.
So decide one issue. If somebody is not coming for that, why he could be?
Therefore, Milord,
he could be forced to wait.
Yes, therefore, Milord, a further so cause already been issued, Milord, and they have asked for the reply.
Why let them do if they don't chose not to appear? Then
therefore,
decide is
yes, therefore, Milord, initialize pre Milord 3 months time is directed can be disposed of. That is what my prayer.
to decide.
Yes, sir, that is what Milord.
Independent case.
Yes, well, that's the only thing they must consider these judgments. That's my humble prayer.
That's what is there.
Because I can demonstrate, Millers, before your lordships, how it is premeditated, and I am not.
No,
although Millers,
if it is so eager, Milord, then I have to file counter so far.
No, I am not on that. All I am saying is that he has to consider.
How can it prejudge the issue, Milord? What the MT or WMT? It has to be adjudicated by the authority, Milord. How can it prejudge and says that I am coming within judgment and coming with all these aspects, Milord? So therefore, Milord, first since I have seen, Milord, with laws
an identical order.
Nothing is identical. Every
Mr.
is a different.
Mr. Acharya, in your submission in brief before the authority, This one, which you have enclosed.
Which one, Milot?
Very elaborate thing.
Yes, Milot. That is at Annexure 7 and 8.
378.
378, Milot.
Yes. In February 2025, you have stated everything.
Yes, Milot.
And also, you have referred to that this judgment also.
Yes, Milot.
In your
everywhere we have referred.
They will consider this.
Yes.
During the course.
That's what I'm saying, Milot. Let them consider that.
Your solutions will be taken into consideration and
Kindly seize
that all the judgments which he has relied upon shall be taken into consideration.
That's all.
That's all. That is what is the main motive.
That is there in the
second is that it is pending despite the direction of the court.
No,
He says that because of the 11 other persons.
that is somebody else. He's not the petitioner. There's somebody else is the petitioner.
No. This is the same company which has merged and the name has changed. It's the same. I have demonstrated that, Milot, at page 36. Yes. There's an NCLT order. So SM Niryat, where the earlier direction was, that became OCL now. Is
a change of name or amalgamation?
Amalgamation happened. Then, Milot, the name.
Amalgamation and,
yes. Approved since 30th of January 2024.
Obviously.
It's the same entity.
Earlier it was cement, now steels.
Yes, Milot. It was.
Yes.
Similar order, Milot, in the same petitioner's case passed by Calcutta High Court.
You have enclosed it.
No, Milot, this is order. I've just given it to the
court. You have enclosed it somewhere.
No, I have enclosed the previous order that was passed by this honorable court. Your lordship is disposed.
No, disposable.
Yes, kindly. So the judgment which has been referred is not covered by this case. It's part of the bill of shipping bills cover. So
His
it's not
only
earlier judgment is
Mr.
not covered.
Mr. Sir, don't show that anxiety. His only endeavor is he has furnished some documents and explanation of this. You are required to take up his explanation, deal with that while passing the final orders.
Yes, ma'am.
That is what he wants.
That he has also relied upon a judgment.
Yes,
You will also take into account the judgment.
So in addition
That's
to
the
this,
only thing.
in addition to
Within
this,
the time frame, you
Yes, sir.
say 3 months.
Yes, yes.
Say 3
That
months.
instruction I have already taken in the morning.
Yeah.
Well, it's
3 months. Submissions to be taken. 3 months,
including the judgments to be taken.
I will finally order 3 months. The aspects will be
right.
So
no issue.
Is it any
That will give a quietness to the issue.
Are you prohibited from proceeding?
Plus, I have given my consent memo. Sir. I filed my consent memo.
What consent?
The appearance.
Whose?
My minutes. I was.
You are not filed wakalatam.
I am appearing along with Mr. Agarwal. So therefore, Milats, I am filing my appearance.
Can you file a wakalatam?
Yes, Milats.
Can you file a wakalatam?
Yes, Milats.
Are you designated senior?
No. So therefore, consent memo.
Great. Obliged. Item number 17.
Your Lordship, the petitioner.
Cancellation.
Yes, sir.
What is this?
Revocation order. Revocation of cancellation. GST.
Have you seen? All the names.
Item 18.
This matter relates to cancellation or essence.
Oh. 19 is also same, your lordship. 18 both the matters.
Yes.
Item 19.
Minus same. Simply.
এটা entire India range চলছে না এটি খালি ওড়িশা তো চলছে
The pan India scenario.
The advocates are your lordship leaving.
That's true.
Your lordship. That is the only.
Like council like Hitesh Tripathi.
Item 20.
RC cancellation, I have given the order.
Now, I think now we have to stop it.
Okay.
You are not entitled. Your
No,
associate will do. Now you have become senior advocate.
No, let's say.
See.
Item 21.
She argued that matter.
Please, my lords. Item 21 is a covered matter, 73(4)(b) matter.
Yes.
Item 22. May I please, my lords.
This is a matter. Before my seniors take the stand, the matter has been already been settled.
No,
Just
but
now
I have
I
challenged these bills. Now, pursuant to
No.
lordship.
If your client has betrayed you and settled it, what remains?
The language used, I don't think is appropriate. Settle means it has far-reaching
the
implications.
demand which has been created, it has been reduced to nil.
Yes.
That just now I got the instruction and
So nothing remains.
Nothing remains. Your lordship may kindly record yes. The order passed by the
just
assistant.
I'll giving that 154 rectification petition within 10 minutes.
Yes,
Yeah.
Give it to clerk.
What was it? So let him, may I say one thing? Let him submit on Monday. Let him give copy of it.
He is giving within 10 minutes.
Yes, we are. Minus.
Order is passed under section 154 ITL.
That's good for your client that he has not communicated.
By reducing the demand.
Sorry, good for you that he has not communicated.
We demand
It has not been taken as a record.
No, I am saying
nil.
that it is good for you that your client has not communicated that his demand has been reduced to nil. Otherwise, Your advocate and record, he would not have requested you to come.
Probably he might not have thought to my client.
Since they have got it off late only.
So it's better for both of you.
That's it.
Item 23.
Well, it is covered matter in absence of just.
Absence of tribunal. Yes. 24.
Item 24.
Wait, please, Your Lordship. Lord, I'm appearing on VC, Lordship, you can hear me? Yes. Yes, can Your Lordships hear me? Yes, yes. Yes. Now, my Lord, the interesting question that arises in this writ petition is whether the VAT credit under the Orissa VAT Act, which was transitioned into GST credit in 2017, can it now be claimed back as VAT credit after 8 years? That is a larger issue. Now, my Lord, I'll just give a brief summary of the facts for Lordship's kind consideration. I'm not referring to any page, just broadly, I'm just mentioning. My Lord, this company had approximately 44 crores of VAT credit. Then, my Lord, 47 crores of VAT credit. They issued two notices to me. Lordship will note, one for a short period of 9 months and the other for a longer period of 14 months. Now, the first show cause notice was set aside by the High Court. It has become final. Your Lordship need not worry about it. Now, please note there was a second show cause notice for the period 1st October 2015 to 36 2017. The Lordship knows on 1st July GST came. So all VAT, sales tax, everything, excise duty, everything merged into GST. So Lordship will kindly note that on the date on which we went into GST, I had availed 13 crores in Orissa and the remaining 31 crores shifted to GST. Now, I challenge this notice. They say that your 13 crores which you took under Orissa Act also is bad in law. I challenged it. The High Court said that you got alternate remedy, sent me back for the alternate remedy. Now, my Lord, this is the main point. If your Lordship now comes to the order which is passed at page 43, there they said you got alternate remedy. Sorry, at page
53.
53. At page 43 is the first writ petition which was set aside, that has become final. Second writ petition for the second period is at page 53, and there they directed me to go back to the appellate authority. Now, if your Lordship kindly comes to the order, please come now, my Lord. This appeal was sent back and number of hearings took place. Lordship may now come to the impugned notice where the problem starts at page 25. Please come to page 25. Has the Lordship got that? No? Page 25. Yes. Now, your Lordship will see the heading is Notice for Enhancement. Yes. The Lordship now sees at the fourth or fifth in the table, the notice for enhancement is on 9/5. The last is 9/5/2025. Notice for enhancement. Before that, if your Lordship sees, it has been heard on more than 8 occasions. This is the order which was being heard pursuant to the High Court's direction to go back to the appellate authority. I appeared 8 times before the appellate authority. Yes. And I went on. Now on 9/5, suddenly issues an enhancement notice. Now Lordship will kindly come to the enhancement notice.
Mr. Datta.
Yes.
This court directed the appellate authority to consider those line of judgments
Ah.
on technical issue.
No, no, no. The High Court said you got an alternate remedy.
No, that Keshav Automobiles and the line of judgment.
No, no, no. That was not the issue. That was not the issue. Since your Lordship asked the question, Lordship will just make a note if your Lordship doesn't mind. 44 crores is the credit availed. 44 crores. 13 crores is the credit utilized. So 44 minus 13, 31 crores is the balance credit. Now the show cause notice was issued as to why 13 crores should not be disallowed. When I challenged it, High Court said you got an alternate remedy, go there. So now this is only concerned with 13 crores. The balance 31 crores I'll come to has become GST and that has become final. Whether that can now be demanded an enhancement is the main question. There's no provision in law for that. That's the main issue. But I thought I'll just satisfy Lordship. Now, please come to the enhancement notice. Please come to page 27. The last but one paragraph, the last 4 lines. If your Lordship has come to page 27, the last paragraph says there is no dispute. Lordship has got that? There is no dispute. Page 27, last paragraph.
Yes.
Just go 4 lines above that if your Lordship doesn't mind. Finally, as on 36/2017, it has carried forward an amount of 31 crores 55 lakhs to the GST regime in Tran 1. Tran 1 is transition. Tran 1 in terms of provision of section 140 of GST and continued to set off the GST, ITC as SGST credit. So all the Orissa balance credit became GST. Now what he says is, please come to page 28. Second paragraph. May I read more? Further, the dealer has carried forward an amount of 31 crores 55 lakhs to the GST regime in terms of section 140. So he admits that this credit has become GST credit. The proviso to section 140 clearly states so and so, so and so. Thus, since the current appeal is against assessment for 110/25 to, it should be 110/2017, not 110/25, 110/2017 to 36/2017. That is the last period under VAT. The admissibility will be determined under this act during the course of the current appeal proceedings. So now he wants to re-examine this 31 crores under the Orissa VAT Act when it has already gone to GST. Now please come to the order, which is at page 766. Please come to page 66. Now my point is, once 31 crores has been approved and gone as GST credit, you cannot again demand it under Orissa VAT Act. That's the law. And I have no appeal against this notice of announcement. Kindly come to page 66. Lordship has got that, Pranav?
Yes.
Now this proceeding was initiated. Lordship will just come to page 66, the last paragraph. The taxpayer is a registered payer under OVAT Act bearing number so and so, duly migrated to GST. On verification of official record as per data available, it is found that taxpayer has carried forward GST credit of 31 crores 55 lakhs, exact amount, by filing Tran 1 and closing balance is disclosed 31 crores 55 lakhs. Now please straight away come to the last paragraph. They wanted to disallow this credit under GST. Now look at what he does after hearing me in detail. Please come to the last page at page 72. This form, you want to and the taxpayer satisfies all the conditions mentioned in so and so, hence your case is kept in abeyance. So what happens is the matter is dropped. Now Lordship will come back to page 65 for a minute. So he accepts that I have satisfied all the conditions. Now please come to page 65. With reference to the above show cause notice for so and so, so and so, the proceedings are hereby dropped for the reasons and other details stated therein. So my transition from VAT credit to GST was sought to be challenged. It was questioned in the show cause notice. Show cause notice was dropped. The matter did not end there. They preferred an appeal. Now your Lordship will come to the appeal at page 80. Sorry, the appeal is at page
74.
74. Battery card. 74. And Lordship will kindly see, they specifically challenge that this credit was wrongly given. Now kindly come to page 79. Therefore, Lordship has got page 79, second paragraph. No? Therefore, in view of the above. My Lord has got that? My Lord, sir. Yes. Therefore, in view of the above, the taxpayer is not eligible to avail ITC on the purchase of goods which he has taken credit, showing the same in the return as 31 crores 55 lakhs. So he challenges the order, dropping the proceeding. Now look at what he does. Thereafter, my Lord, he then says, kindly come to page 80 is the appellate order in the appeal. Look at the interesting thing what happens. Please come to page 81. After necessary examining the petition, my Lord, second para, my Lord, is got after necessary examination. May I read, my Lord? Page 81. Sorry.
It has been withdrawn. They
Yes.
chose to
Appeal has been withdrawn. So the
So,
GST
sir,
credit has
what is
become
stopping
final.
the proceeding attained finality?
Yes. And now this order is passed on 16th of May. Now on 9th of May, 1 week before the withdrawal, order is passed. He files the application to withdraw on 9th May. The order is passed on 16th. On 9th May, the very same amount of 31 crores, he wants to demand as Orissa VAT. He cannot do that. It has become GST, it has become final. How can the same amount become VAT? And the other point I'm raising as a civil point, my Lord, the High Court remanded the matter to dispose of the appeal as filed. It's not an open remand. It's not an open remand. Lordship knows, your Lordship remands the matter saying leaving all contentions open. Parties can say whatever you want. High Court simply says
Lose bond. Is a limited remand.
the limited remand. How can he now issue notice of announcement after 8 years? That's a short point, Lord.
Yes.
I don't mind, Lord. I want to say one thing. I don't want to. On that 13 crores, it is decided on merits. If I lose, I will go to the tribunal whenever it is formed. But he can't now, in that appeal regarding 13 crores, issue a notice of announcement of 31 crores on the GST amount which has become final. Appeal has been withdrawn. That is the short point.
Your Lordship, let me clarify on this point, then I'll go to the other point, Your Lordship. Your Lordship may kindly turn to page 72. The order
You better file response.
I'll file. I'll take liberty to file, Your Lordship. Prima facie, if Your Lordship will permit, prima facie, because it is a notice, so cause notice and read should not be maintainable. And there are plenty of judgment and Your Lordship.
No, it is not notice simplicitous.
Your Lordship, enhancement notice as
It is out of certain proceedings.
No, Your Lordship, only 2 minutes, only 2 minutes.
If it is done with some kind of a motive,
Well,
and to say thwart what has already been extended to the SSE, then in that event the court can definitely go and lift away that what was
Your Lordship, I'm not on.
is required.
I'm not on that way, Your
Mr.
Lordship.
Mr.
I'll file counter.
Mr. kindly appreciate
Well,
Annex 12,
Your Lordship.
to which Mr. Datar has taken taken us to, that
Your
is
Lordship.
page 80.
Your Lordship.
That is at your behest.
Your Lordship.
That is important.
Annexure 10 for a moment, Your Lordship, the adjudication order. Your Lordship, prima facie, I may be permitted to place prima facie, Your Lordship. I'll file counter, Your Lordship, within 5 minutes.
What was the proceeding
Your Lordship,
which was dropped?
Quite dropped. How? What?
No,
Your Lordship,
no, sir.
page 72.
There is nothing. The question is the ultimate decision that it is dropped.
No, why dropped? Your Lordship.
Why dropped is not coming up.
Dropped because that is pending. Because the appeal is pending, Your Lordship may kindly turn to page 72. For a moment, Your Lordship.
Sir, you challenged that order before the appellate authority.
Your Lordship.
Challenging the order, dropping the proceedings. And then you consciously withdrew it.
Your Lordship.
And withdrew when? Beforehand, you have already issued another notice.
No, Your
And you withdrew later on.
Simultaneously. Not withdrawn later on, Your Lordship. Simultaneously, Your Lordship. When it has been realized that it has to be done in the S12 Act, Your Lordship, and the law is well settled. Honorable Jharkhand High Court, as per section 140, transitional provision, as well as 174, Your Lordship, Honorable Jharkhand High Court has decided that Tran 1, Your Lordship, the figure in Tran 1 is to be adjudicated in the S12 Act, not under GST Act, because it cannot be automatically transferred. Your Lordship, 140 subsection 2, may kindly, only prima facie, Your Lordship, section 140 subsection 2 says, when it is admissible, not automatic, what is cry for word, that has been allowed. It has to be admissible in the existing law, Your Lordship.
You have not see.
You are improving your case. It will not appear.
Everything on record. I have not passed any.
You have lost the bus, missed the bus, because so motor revision you have not in.
No, so motor revision.
Neither under VAT.
Your Lordship, when the appeal is pending, Your Lordship, only one judgment, Your Lordship, may kindly peruse. So far as the 140 and 174. How that Tran 1 has been rightly adjudicated in the S12 Act, Your Lordship. It cannot be adjudicated under the GST Act.
So after 8 years, you will adjudicate.
Your Lordship, because the proceeding was pending. For that reason, Your Lordship, the adjudication has been done.
Suspend the operation of the repetition.
No, Lordship, when the appellate 77.7 says, Your Lordship, for a moment, section 77.7, section 77.7 clearly says the appellate authority enhance the assessment, including any part thereof, whether or not such part is the subject matter in the appeal.
That is under VAT.
Yes, I am under VAT, Your Lordship. I am under VAT, Your Lordship.
That was already over.
No.
And attained finality.
No. Your Lordship may kindly look into that judgment. That judgment of it is under 140.
Yes, you find your response.
Your Lordship.
Find your response and
Your Lordship.
What is the order?
It is the notice, Your Lordship.
The notice.
Notice, Your Lordship. So what I pray, let it be adjudicated, let him file reply. No final order may be passed.
Let us see. If on the pure question of law, if it appears that it cannot be sustained, then in that event has to go.
Your Lordship, I think with great respect to my Lord Senior, Your Lordship, I think I have a case here.
Sir, I think the line of judgments which are relied on India Limited.
Your Lordship.
India Limited as such may not apply. But the line of judgments which were relied on in the...
Here, Your Lordship, the facts are very much clear. No ambiguity.
That is what clicks. The facts are more or less clear.
Your Lordship.
And then now the question is that how you have perceived the fact and how they have perceived the fact. You have perceived in your own way. They say that it cannot be done after those facts. So this is what we have to.
Your Lordship, then let us sing.
How soon you will file your response counter?
Your Lordship, within 2 weeks.
2 weeks. No, I may permit a rejoinder if necessary within 1 week thereafter, if at all necessary.
Let us see that.
If any,
Response.
Your Lordship.
matter to appear after 3 weeks. Deeply.
Your Lordship, I have everything. I can substantiate you.
No, let them not proceed with the enhancement notice as well. That is what we say.
Item, yes, Your Lordship. I am for the appellant in this case, Your Lordship. Item 25. May it please, Your Lordship.
This is the admission.
My Lord, this is a fresh admission.
After 2 minutes.
Yes, yes, my Lord. Yes, my Lord.
Within.
Blank. I pray, Your Lordship, for 2 days time. Today I am not well, Your Lordship. I have taken medicines, Your Lordship.
The only purpose they are lingering in the matter.
I am submitting, my Lord.
Personal ground is
That's
where
I understand.
keep it on
let it come on 16th, Your Lordship, along with WA number 1082 by 2025, a connected writ appeal of the same parties, same proceeding.
Tuesday, sir, come.
My Lord.
Tuesday.
My Lord, my Lord, my Lord. Along with WA number 1082 by 2025.
We'll see to it.
I have given the number to the court master, Your Lordship.
Yes, next.
Item 26.
26, my sir, I have filed an interim application for withdrawal of writ application. Yes. And friend is here for the opposite party.
Yes. What do you say?
No. Item 27.
I beg to withdraw the matter. I pray to withdraw the matter, my Lord, with liberty to file a better application.
Why?
My Lord, I have instructions for.
Why liberty?
My Lord, to file a better application.
Withdrawal with liberty.
Item 28.
Suffer a limit of
28.
For 3 weeks.
Item 29. May it please, madam. Here, my lord, the petitioner was awarded with the work for mechanical transportation of cost coal by tippers from feeder breakers of Jagannath Colliery to siding number 1, 3, and 4 of Jagannath Colliery of Jagannath area for a period of 1 year, my lord. My lord may find the tender notice at page 23. It was for 1 year, my lord.
Yes.
On 23, 2012. Thereafter, my lord, on 7/8, annexure 3, my lord, on 7/8, 2012, my lord, the agreement was executed. Thereafter, my agreement executed, then, my lord,
yes.
my lord may see page 39, my lord. It's a Mahanadi Coalfields, my lord, Office of Project Report, Jagannath Colliery. The time-bound program, the name of work is Mechanical Transportation of Coal by Cost Tippers. My lord, the date of commencement of work was 4/7/2012 and 3/7, my lord, after some extension, 3/7/2013 is the date of completion of the work, my lord. Now, after 10 years, my lord, page 12 is the impugned order. In the impugned order, my lord, may I place it, my lord?
Yes.
Revised estimate, closure of contract. in reference to the approval order dated 30/3/2023 of General Manager. This is to convey that the approval of the competent authority for the revised estimate for executing 2351,443 40 ton, my lord, for a period from 4/7/2012 to 26/10/2023 for a period, my lord, that is 23 they have written, but it should be 13, my lord, for a total amount of value is 92 crores, my lord. After that, excluding the service tax and excluding the escalation for the work of mechanical transportation of crushed coal by tippers from feeder breakers of Jagannath Colliery to such and such against the work order number dated 25/8/2015. Thereafter, my lord, this is the entire breakup that they have provided. Then the next paragraph, the shortfall penalty on account of contractor's fault is rupees 4 crore. It's 4 lakhs approved by, which was communicated by a revised AO NIT dated 15/10/2022. The revised estimate closure of contract amounting to rupees 4 lakhs. There it is, my lord.
4 crores.
Sorry, my 4 crores. Thereafter, my lord, the details of the are below, my lord. So here, my lord, they have given the detail, the executed amount of executed quantity from 4/7/2012 to 26/10/2013, the amount to be paid and amount already paid, and payable recoverable is 3,30,000. Then, my lord, diesel escalation from 4/7/2012 to 26/10/2013 on executed quantity. Then, my lord, the recoverable amount is amount already paid is 4 lakhs, 4 crores 7 lakhs. Thereafter, my lord, they have given the total amount, and total amount that has to be recovered is 7 lakhs 35,000. Then, my lord, details of recovery of shortfall and other recoveries. Shortfall penalty is 4 lakhs 70,000, and balance to be recovered is 4 lakhs 70,000. Then amount to be recovered on account of differential wages from the month 2013 to June 2013 to October 2013 is 38,000, and total is, my lord, 5 lakhs 9,000. Thereafter, my lord, again, the given and retention money. This money, my lord, 3 lakhs something has been refunded. Total amount now, my lord, it comes to 12 lakhs 44,000 to be recovered from the contractor. The amount of 3 lakhs 28,000 is available in lieu of cash as retention money. Hence, the balance amount of 9 lakhs 15,000 is to be recovered from the running contract of JRT JB contractor under NIT 843/25/2022 in Jagannath area. My lord, my humble submission is this.
My lord. My lord. I'm appearing in this.
You are appearing.
Yes.
For MCL.
My lord.
Filed your counter.
Yes, my lord. I have filed my counter. He has not filed a rejoinder. In the meantime, what my lord has happened? This matter was sub judice. I mean, the subject tender was sub judice before this honorable court by the same petitioner from 2012 to 2019. There was an interim order operating. It has only been vacated in 2019. So, my lord, the delay being attributed to me may not be wholly correct. Now, my lord, your lordship may see there is no document which the petitioner has filed consciously before this honorable court that he has why he has not pursued the remedy before the authorities. Not a single document after 2013 directly the impugned order has been filed. My lord, the reason was, my lord, this matter was pending. Now, my lord, there were two things which had to be recovered from him. In the closure of contract, there was a price fall clause. My lord, what happens? There is a direct clause in the contract. If he is allowed time extension, that time action extension will come with a rider that if the next tender the price is low, then that amount which is the next tender's price, according to that price we will pay you. We will, if we have paid you in excess, we will recover. That's a direct. I have avoided in my counter affidavit. I will take your lordship there. And the other thing is, there are some shortfall penalty. Shortfall penalty, in fact, my lord, 4,70,000 has already been recovered. And my lord, here periodically, when he is not able to deliver the work as per the progress agreed, there is a shortfall penalty. I take your lordship to the counter affidavit, my lord. My lord, may kindly come to page 91. And before that, I'll show you a lot.
Prepare note of argument, both of you.
My lord, can I submit one thing? My lord, I want to submit. My lord, he has submitted many things. My lord, if my lord will see the impugned order. Impugned order, first of all, my lord, after 10 years it has been given to me. No show cause notice was ever submitted to me. And whatever the averments in the counter affidavit they have taken, it is an improvement on this impugned order, my lord.
So please, short sorts of argument. If you want to say that take advantage of any judgment of the
Yeah, my lord, I have the judgment, my lord. MS Gill judgment.
MS Gill judgment. That
yes,
is, I know the
my
MS
lord.
Gill judgment. So
My
if you want to take advantage, take it. Limitation period when you talk about.
My lord.
I do not know. It's a 10 years or a 20 years for the garment. It is has to be understood. He say there was a interim order not to proceed. If that being the position, whether they can take advantage of.
If that is the question, my lord, then it is 2019 that order was withdrawn.
So 2023, according to
yes,
this, still there is a gap of 4 years.
4 years, my lord.
File
And my lord, the most important question, without a show cause notice, my lord.
State that.
Yes, my lord. Yes, my lord.
Not file it.
I'll do that. My lord, there is a specific consent of the party that you impose price fall clause. My lord, it is at page 97. So no notice was necessary. I'll anyway, if your lordship desires, we'll file written note of submission.
Yes, please file.
My lord. Watch.
How soon?
My lord will file it by Monday, my lord, or Tuesday, my lord.
A week's time, my lord. May.
No, that's not a delay. 60 days delay. Yeah,
30.
2028.
28. 28 is over, sir. We are at 30. And who is in 30?
Item 30. Malad, sir, I'm appearing on behalf of Mr. Parija. We need a passover, Malad. He's on conducting counsel. He was in legs, Malad.
Copy has not served. Why don't you file it? It is already there on record.
Don't have a copy of it.
Rejoinder is there.
Just need a passover, Malad. I'm out.
Mr. So on behalf of
Item 31.
Well, your lordship, the review order is that of the binding officer. There's always a appeal provision under 46 with 46, your lordship.
Because this has been transferred from the tahsildar to the mining officer, so they are supposed to file the affidavit.
I mean, but there is an appeal for provision under Rule 46. The deputy director fine. Any order passed by the mining officer is approved.
At the request of
Chapter 32.5. Rule 32.5 says, if you want to cancel the lease, then you have to give opportunity of personal hearing. But here I have specifically stated, though in the order they mentioned that in spite of notice nobody came, I have specifically mentioned no opportunity of hearing has been given. That is the reason why Your Lordship wanted him to file an affidavit.
interim order is in your favor.
Right. Interim order has been passed.
What?
Go on appeal, Your Lordship.
On the ground of violation of principle of natural justice, one can.
Right.
Even an alternative remedy may be there.
Lordship,
So,
but that can also be.
why should we? We have entertained this writ since long.
Yes, Your Lordship.
So
But the
now at
president-
this stage, can we go for that?
Then Your
It
Lordship,
ought not to have been entertained at the first instance. But there was a direction for filing the affidavits.
the Tahsildar has filed an affidavit. Now it has to be the mining officer, Your Lordship. The Tahsildar has stated that all the records have been transferred to the mining officer, Your Lordship.
That is exactly I say. This would
So
file.
you file
That
an affidavit whether natural justice
Yes, Your
is complied with or not,
Yes, Your Lordship.
and who is the competent authority to proceed with.
Right.
Yes, sir.
To that authority, we will see whether it can be. The request of Mrs. Patnaik. Increment first level, so we know next to people.
Publish.
Item 32, your lordships have already issued notice in the matter. This relates to, my lords,
How a PIL, even if we consider this as a PIL,
my lord,
how it lies is a policy decision of the government. How much money is to be disbursed?
No, my
to
lords,
particular
here policy
yojana,
decision, my lord.
where it has to be restricted.
No, my lords, here the policy decision has not been made applicable to the small and marginal farmers.
That is what I'm saying.
My
That
lords,
it is everything has its own.
here, no, my lords, here what has happened, the
Brother, show us that the PIL lies in this.
my lords, here, my lords, what has happened? I'll demonstrate before your lordship. If your lordship takes up Annexure 1.
I am at Annexure 1.
Yes, my lords. The MSP which has been fixed all across India is 2,300. Now, Orissa is giving 800 rupees more to the farmers. If your lordship sees at running page 15, rising cost of cultivation, cost of production for paddy, with enhancement in prices of inputs and farm labor has become a matter of concern. The effect of farm mechanization is lowering of operational expenses is yet to have its spread effect. In view of the aforementioned facts, a new scheme, namely Samruddha Krishak Yojana, with following objectives have been initiated for providing input assistance to farmers, which will be empowering them befittingly. Now, my lords, this input assistance doesn't make out, once they are in the policy itself, they don't make out any classification. Then your lordship says the scheme objectives, that is at running page 16, increase in sustainable food grain production for the state, promotion of new technologies in crop production, encourage and increase in production and productivity of the crop, assistance to farmers to invest in quality seeds.
That is good.
Yes, well, exactly. My lords, we are wholly with this policy, but why should it not be made applicable to the small and marginal
Where
farmers?
is the barrier? I do not.
My lords, farmers who have registered to sell paddy through the existing mechanism of the Department of Food Supplies and Consumer Welfare will be paid 3,100 per quintal, including the input assistance under Samruddha Krishak Yojana and the prevailing minimum support price. That
It's open for all.
no, my lords, here what is happening, this
input price might be given to them who are cultivating the land
no,
and
no.
supplying or selling their price seeds to the government through the civil supply corporation, my lord. So that is intended to make the cost of production and all that.
Exactly, my lords.
Apart
Now,
from
what
that,
about the
other
small
support
farmers,
price have been
small
paid
farmers
by the
who are
private petition
selling
and
it locally, who are
Well-
consuming the rice themselves for their own sustenance, my lords, that they will be excluded. The policy makes
If you cultivate for your own consumption, then why MSP?
my lords, MSP is given to all farmers, my lords.
Correct. If you go and sell it,
My
either
lord.
in the open market or to the government,
My lord.
then that is a minimum guaranteed price
My lord.
that the government will pay you per quintal or per kg or whatever.
Exactly.
So
Exactly.
if you do not go and sell,
My lord.
then
No, my lords, the MSP is given to us. It is not, my lords, there is no difference between people who are selling to the government and not selling to the government. 2,300 is paid directly into their accounts. This is all over India. Suppose I don't sell to the government, still then I get 2,300, my lords. I'll give your lordships the statistics. It comes directly to the account of the farmer. So how can they deprive me of the 800, my lords, when I'm a small and marginal farmer? That is our case. I will demonstrate before your lordships.
where is the concept of MSP? Show us. What you are saying is something which is new to me. Show me. But what is the scheme of MSP? What does it mean?
Are under Annex 2 and Annex 3.
My lords, other input subsidies are under
There are two other inputs.
Annex 2 and Annex 3.
Page
23. CM Kisan is a farmers welfare state plan. This is another input subsidy, just like the present one, my lords. Support to farmers for cultivation,
Much like the other.
much like the other one, my lords. Under this component, support shall be provided to the rural, small and marginal farmers (SMF) 2,000 per crop season, totaling to rupees 4,000 per annum for purchase of different agriculture inputs like seeds, fertilizer, pesticides, as well as to meet the expenditure towards labor charges and other investments in the field operations based on the farmer's choice. Now, my lords, this input, this 2,300 is given to us not only for purchasing the paddy, also to invest in the seeds.
This guideline of CM Kisan.
Yes, well.
If you look at it, is a welfare state plan scheme. Primary object of the scheme is to accelerate the agricultural prosperity.
Yes.
And to empower the farmers. The scheme is progressive, it says, as well as the non-loany farmers. The project is, it will cover 92% of the cultivators, loany as well as non-loany farmers, and landless agricultural households of the state. So this is a welfare scheme which is paid to them.
My lords, this
But
welfare
what is the minimum support
Minimum support price, I will
I am
demonstrate.
just asking
I,
that
I,
what
I
was
will get this.
the objective of MSP
Malad.
to be introduced? What is that? I just
Malad,
wanted how it works.
Malad, the objective of MSP, once I produce, let us say I produce 10 quintals of rice, let's say. So for 10 quintals of rice into 2,300, for example, I don't get this 800, it comes to 23,000, which directly flows into my account. That is how, and so my what I am saying.
No, I am just, I have a confusion. Please eradicate this. Minimum support price. I do not know why the MSP which came was that is, suppose if you want to go to a market, there are many, I would say, the interveners, there are many brokers, there are many intervening parties.
Exactly.
They may not give you the liquid or appropriate or reasonable price.
Yes.
It says that if you come, this is what a standard price, support price we fix. Nobody would be able to pay you less. They have to pay you this minimum price.
Exactly.
When you go and sell your produce, great. Suppose somebody does not go and sell their produce, still they will be paid because they have harvested, let us see, 10 tons of the paddy. So they will be paid without this, irrespective whether they will consume themselves or what. They do not go and sell, but they will be paid by the government. Shows that this is what is the motive of MSP. My understanding is different.
I'll give you
My
lordship the
understanding is
statistics.
different.
I'll give you lordship the statistics.
One is
Yeah, I understand your
something-
lordship's
yes.
query, Malad. I'll understand your lordship's query. I'll give that statistics to your
Please.
lordship. Malad,
Show
I'll
us
get those documents.
when those why MSP was introduced, what for it was introduced, what is the objective? It's a welfare piece of scheme.
Yes, Malad.
Let us see.
Malad, I understand your lordship's query. Your lordships may take it up next week.
I have no idea about it.
Malad, I'll get all the documents which
You
will
also
show
come with
that it directly flows to the farmer's account.
Let
I'll
us
get
see.
those.
Let
Yes,
us see.
yes, certainly.
When?
Any next week or week after next, as your lordship.
Fix it. After 2 weeks, you come.
Certainly.
Please bring that scheme.
Yes, sir. After 2 weeks.
Item 33.
Oblige.
Your Lordship, Mr. Gulati mentioned it today in the morning. He wants to appear here physically and argue the matter. Mr. Satpathy is here. I request your Lordship on 8th of August if the matter can be.
Yes.
Grateful.
Item 34.
Lordship, last occasion, your Lordship directed to deposit 20% on tax that I have deposited. But with regard to interim order, file one IA for modification in respect of interest.
More proceedings. The event of deposit. No courts and steps are already there. What more?
That I want to that incorporate the challenges made in the writ petition.
So at the interim stage, it should be cost. Very interesting.
No, quest not quest. It is stay only.
We have said that the no course and stay would be taken.
No,
we will hear out the main matter.
Then with regard to interest, your Lordship pray.
It's not an interest. You pay for the time being. What we
20% paid already. Tax already paid 20%, Lordship. 20% already paid tax with regard to interest only.
20% of the interest also. Whatever we have passed, we have passed. We will stick to it.
That are relying on the
I know where you are heading. I know, but that is not permissible. But still, once we have passed, you.
It is interim order in the prescription when it is pending.
A court can put the parties to a conditions while passing an interim order. Condition does not mean that the condition must be strictly. The court can. That's the bona fide one has to show. So we have included the interest. No, so
that notice may be issued to the opposite party 7 also. Supplier, that is.
Double 814 of 2025. Modification product. No interference for IA stands 50. No interference.
Right, please, my lords. This is the writ of my lords. To admit the appeal, my lords. Sorry. Sorry, 23/6/25. The appeal has been admitted, my lords. That's if your lordship will kindly go to the judgment, my lords. That is annexure 8 at page 81, my lords. My lords, your lordship will kindly take it up, my lords. Writ appeal number 9. There are two writ appeals. First is writ appeal 965 of 25, my lords. There is a common judgment in both the matters. 965, my lords. It starts from 81. 966. And the issues framed by the Honorable Single Judge, your lordship will find at internal page 11, my lords. 11, internal 11, it starts from page 92, my lords. Three issues have been framed.
That's a 966 appeal.
No, 965.
965. 965 page 81 नहीं
92 per page. Page 92.
you are referring in the impugned order.
My lords.
See the internal page 11 you are referring.
My lords. At page 92.
Whatever.
Page 92. Running page 92.
It is not tallying with that. Anyhow, internal page we can.
My lords.
Paragraph 9 or a 10 or what?
This is paragraph 8, my lords.
8, continuance.
My lords.
Yes.
But whether the reduction of sanctioned cash credit limit by the respondent bank from 14 crores to 6 crores as communicated on 13/11/2024 was legally justified and carried out in accordance with due procedure. 2. Whether the classification of petitioner's cash credit account as a non-performing asset (NPA) on 30/12/24 was in compliance with the applicable guidelines issued by the Reserve Bank of India and supported by relevant facts. 3. Whether the respondent bank levied and capitalized penal interest in violation of judicial distance and regulatory directions, and if so, whether such action is sustainable law. But so far as first issue is concerned, the respondent here, he was availing cash credit loan, and that was continuing since 2006. As my lords knows, unlike term loan, cash credit loan is provided by the bank for a period of 1 year. It can be less also, and from year to year this gets renewed subject to compliance of the terms and conditions stated therein. But the last of such renewal was done on 1/11/2022. There, conditions are there that you have to maintain your accounts and maintain cash flow and see that the terms and conditions scrupulously complied with. But that was not complied with because for 2023 and 24 and 2024, for these consecutive 2 periods, the balance sheet shows that they have a loss of first year 3 point some odd crores and second year 7 point some odd crores. But they have miserably failed in making deposits. It's a public money, so therefore we said that unless you serve interest liability and you pay at least have transactions, because you cannot make a claim that 14 crore is there. So because I am within that limit, that also they have exceeded several times. I'll show from my statement, to lordship, they have exceeded even the credit limit, and they say that because within that limit, so therefore you cannot reduce it. That's what we have done. when all those continuously mirrors, the conduct of the respondent was found to be not complying to the conditions of the sanction order mirrors, mirrors, the bank called upon the mirrors managing director to come for a discussion for the purpose of reducing the limit. We say that we are not stopping this, but because of our business condition, we are not, even we could have recalled also, because the conditions also says that at any time without a reason also you can recall, but we have not recalled. We discussed for reducing the limit mirrors. And mirrors, that happened on 13/11/2000, mirrors 23. And thereafter, after discussion mirrors, bank filed communication dated 14/12/23, mirrors reduced the limit in a phased manner. That is annexure A of the counter affidavit. That's when the petitioner respondent mirrors filed writ petition before the honorable single judge mirrors. Mirrors, these letters are not given, and these conditions of this phasing out of this cascade mirrors, that was accepted in writing by the respondent mirrors. Those communications are so vital, it is supposed to be brought to the notice of the honorable court mirrors. Before the honorable single judge, the writ petition, those are not filed mirrors, and I brought to the notice of the honorable single judge mirrors by filing the counter affidavit mirrors. Now I will bring to my lord's notice mirrors. In the writ appeal, now I have annexed those two documents, which I have already annexed the counter affidavit. Your lordship may kindly turn to mirrors annexure 1. That is at page 25 minus. Mirrors, the caption is CC account number so and so, irregularity in limit renewal oblique continuation, the position of the accounts as on date as follows. You also kindly see the table. There are two accounts.
Sir, you are at
everything. Where is a writ petition? He is referring a writ petition.
No, I am referring to writ appeal. Writ appeal also I have annexed.
Writ appeal 966.
965 of 25 minus.
No, actually the pages are 966.
No,
I am also unable to find out.
So that is
966.
Mr. Dilip Mahapatra, you have not corrected your brief.
You have not corrected, sir. This what you have given is 966, and that's why he's mentioning the page. We are unable to find out.
You should have
You have given a wrong number to the brief. It is actually 966, not 965.
So let it be, your lordship kindly, I am so sorry for 966, your lordship kindly take it up there.
Yes.
Minus. Annexure 1 at page 25. So this is a serious mistake.
No, it's not a serious mistake. It's an inconvenience which is caused.
Minus.
Nothing more than that. Yes.
Mirrors, page 25. Your lordship kindly see for a while. Page 25, I am reading the caption mirrors. CC account number so and so, irregularity in limit.
Yes.
Irregularity in limit, renewal oblique continuation. The position of the accounts as on date is as follows. But there are two accounts operated mirrors. In the case of this response, one is cascade account and other is mirrors GCL account. It's a term loan. Second is term loan account. In the first cascade account, your lordship may kindly see the facility CC account number is mentioned. Limit is 14 crores. Outstanding is 14.17 crores. Irregularity mentioned 0.20 crores. 20 lakhs. That is 20 lakhs. Then the other account, limit is 1.32, outstanding 1.32, and 0.20 is the irregularity. Total irregularity 20. We request you to regularize the account by crediting the unpaid interest amount in the CC account at the earliest. Further, we would like to inform that based on the discussion with Mr. Pratap Kishore Panda, Managing Director of the company, on 13/11/23, continuation of credit limits has been allowed by the appropriate authority with the following conditions oblique stipulation. FVWC outstanding limits. FB means fund-based working capital. Fund-based working capital outstanding limit to be brought down to 9 crore latest by February 2024 by deposit of receipts from government authorities for Lokvitakis, ROB, Sambalpur, work order and or any other order received cash flow, and further reduction to 6 crore by October 2024. That is reduction of 1 crore at every quarter. Meanwhile, we request you kindly apprise us about the status of receivables from various government departments and submit the details about the new work order, if any. There's this communication of phasing out of the cascade limit mirrors. that was accepted by the respondent, my lords. Your lordship may kindly see the next page. Annexure 2, that is letter dated, my lords. 21/5/24, my lords. Request for condonation of time for limit reduction. Dear sir, we understand that we have accepted your credit sanction dated 14/12/23, just the letter which I read out for lordship, my lords. 14/12/23 for reduction of our credit limits from the existing levels in a phased manner. Our commitment was based on an expectation of receipts from government departments for our execution contracts. Then they mentioned that for ensuing election, we are not getting payment. As soon as you get it, we pay. All our payments are delayed due to start of general election for both state and central. Subsequent implementation of the code of conduct, as all government officers from department preoccupied with the election. We hope to get funds within 90 days from the date of new government formation. Then you lordship may kindly turn to the next page. On the very same date, another communication made to the bank, mirrors. That is Annexure 3, request for continuation limit, mirrors. We came to know that our credit limits with your bank have expired on 17/5/24. We hereby request your estimate bank to give us time of 90 days to regularize our limits and submit further documents, if any, mirrors. Now, mirrors, in the writ petition, the corresponding writ petition, mirrors, will be, mirrors, 31627 of 24, mirrors. Here, there are two prayers. One of the prayer is this, mirrors. And your lordship will find so the documents annexed to writ petition, mirrors. These documents are not filed, whereas the ultimate, mirrors, the execution of what we have proposed, mirrors, that was challenged. Because the petitioner challenged, mirrors, Annexure 8 sanction letter dated 13/11/24. Let me place, mirrors, from WPC 31627, mirrors. This arises out of this, mirrors. That is at page 54, mirrors. Of WPC 31627 of 24, mirrors.
Page?
Page, mirrors, 54, mirrors.
Yes.
Page 54, minus. Whereas the proposal for phasing out, which was discussed with the managing director and communicated with us and that are accepted, that is now given effective by this communication dated 13/11/24, minutes. With reference to your advances to SAB segment, sanction of credit facilities, with reference to application requesting us for renewal of working capital limits, term loan limits, and subsequent corresponding in the regard, we have the pleasure in advising sanction the following credit limit, which are available subject to your acceptance, fulfillment of terms and conditions, detail in Annexure A, B, C. Existing limit, your lordship will find the column, the table, facility, existing limit, sanction limit. This FWCC cash credit limit existing was 14 and it was made to 6 crores. Revised to 6 crores. Then GCL was 50, existing 50 and this sanction limit is 50. Total fund 14.5 is 6.5. Bank guarantee, this is not the issue here. 14.5 to 6. So therefore, when the cash credit limit was phased out and decision was taken by the bank, after discussion with the borrower, that was not challenged. And when we implemented the earlier communication, which was a consensual rather, after discussion, now this is challenged. So, we have relied upon one judgment before the honorable single judge, that is in the case of Amarjit Singh, that said that without challenging the basing order, you cannot challenge the consequential order. That is the fundamental. I will not say much into that, but in any case, the borrower was found to be accused with this. He didn't have any grievance, when all those communications made, and he himself accepted. Now he says, as if I am not aware of all this. And before the honorable single writ petition, he didn't file those petitions, keeping the court oblivious of those vital documents, Now he challenged the consequential order. Now what has happened? If your lordship will see the writ appeal, the judgment under improved under the writ appeal, which I was placing a little while before, Annexure 8 at page 81. Out of the 3 issues, the first issue deal with this. And in the judgment, your lordship will find there is no whisper or anything, Even though in my counter affidavit, Because I may not like to burden much on your lordship by placing all those. But in the counter affidavit, I have annexed, I have also placing just now the letter dated 14/12/23 minutes, the acceptance dated 21/5 minutes. All those documents are there. So despite of, and the decision which I rely upon, despite of all that, nothing is considered by the honorable single judge. And without giving any reason, without deliberation, analysis, anything, even though the judgment reads discussion analysis, your lordship may kindly see how the honorable single judge has dealt with. Your lordship will find the entire thing starts from after mentioning the stand of the petitioner opposite party. Now your lordship may kindly see court's reasoning analysis that starts from page 91. Page 91. Now, in the court's reasoning and analysis, your lordship found initially it started framing issues. Then on this issue, issue number 1, that was not considered anywhere except there is some whisper at page 95, paragraph 17. That's fine, nothing. I have checked now. Page 95, paragraph 17 for a while. May I place belows? Taken cumulatively, the action of the bank, including the unilateral reduction of credit limit and the unlawful capitalization of penal interest, reveal a pattern of opacity and a disregard of regulatory governance. This is the only mention regarding reduction of cash credit limit. Nothing else. And ultimately, what is the finding? Your lordship will find conclusion. In view of the foregoing, this court is of the considered opinion that reduction of cash credit limit from 14 crore to 6 crore was procedurally flawed, and in the absence of fair notice or opportunity is liable to set aside. But opportunity telltale mirrors. It is a consensual phasing out of cash credit, consensual. Discussion was made with managing director. And the reason why it is reduced it was not earlier, why this? For 2 consecutive years, it's both out of pleading mirrors. 1 year 3 points of odd crores loss, second year 7 points of odd crores loss because there is no cash flow, and the deposits which are either not made or if made, they have referred to mirrors out of order, definition of out of order RBI regulation. That says that one of the conditions which the honorable, with all respect, that was omitted, not mentioned, that says even if they are making deposits, credit is available, but if the credit is inadequate to serve the interest, that can be one of the grounds to treat the account to be out of order. So therefore, that has not been dealt in. Out of order, but this aspect is not. So therefore, my humble submission, I will also take your lordship's attention, to the statement which I have filed in my counter affidavit before the honorable court. This is also telltale regarding the conduct of the correspondence. But in any case, your lordship will find nothing is dealt in. Because your lordship may kindly see the counter statement document. That is statement the bank statement. Bank safe now on H3 plus writ appeal page 23 minutes. Petition is there. There. Statement, yes, it is there. Minutes, sorry, I'm so sorry. Annexure 7, it runs from page 29 to 53 minutes. Of WPC number 31627 of 24 minutes.
Annexure?
Sorry, minutes.
Annexure?
Annexure minutes 7. Page 29 to 53 minutes.
Yes.
Your lordship may kindly just have a eye on the right hand side, the balance column. Before that, your lordship may kindly see from page 29, cleared balance. This is the balance mentioned on that day. Of course, on the date of statement on 10/12/24 minutes. Then the limit is 6 crores. By that time, it was reduced to 6 crores minutes. Then drawing power. That is another point my lord have to keep in, because the cash credit which is granted by the bank to the borrower, that amount is not permitted to be utilized. It is the drawing power that matters. Because the drawing power under the RBI guidelines is also determined for the purpose of permitting the borrower to make withdrawal. And there are certain basis for calculating the drawing power, like the receivables, the available stock, all those things. Supposing this amount is rare, he is not making deposit. He doesn't have corresponding stock with them, or he has no receivables. Material is diverted, fund is diverted for other purposes. To have it regular millards, there is a provision as per the RBI guidelines to assess the drawing power. He cannot go beyond the drawing power. So Miller here after reduction it is 6.6. But in other cases, your lordship will find when 14 crore is the cash credit limit, drawing power might be somehow 13 crores or 12 point something like this. It all depends how it is calculated, and it varies from time to time. Now, my lords, your lordship may kindly, as I said, have a look at right hand side, the balance your my lords will find. Always your lordship find more than 13 crores outstanding. 13 crores for 44, 13.
Next page.
Next page. 13 crores 73. And at some places, I have already shown to the Honorable Single Judge at page 33, my lords may kindly see for why. Page 33. The balance is 14 crore 1 lakhs 97,000. Then 14 crore 19 lakhs 81,000. 14 crore 23 lakhs 9,000. 14 crore 42 lakhs 91,841. 14 crore 43 so and so. 14 crore 62 also below. So, Millers, many a times, even they crosses the Millers, the CC limit, not to speak of Millers, the drawing power, they have exceeded this limit also. So, therefore, the conduct, Millers, I will not burden your lordship so much everywhere. That is why I just request your lordship, Millers, to turn up the pages and find out what balance
is to be blamed.
Millers,
If they withdraw or a draw more than the limit, then who is to be blamed?
Absolutely, your lordship. I am keeping mum. I cannot react to what my lord's comment. Many a times, my lords, banker also, they want the business to withstand, not to demolish. Many a times.
They take the advantage of their own wrong.
So, Millers, I do understand, but once we have done and once we have declared, Millers classified the account as NPA, Millers, my friend's client again came up in another petition. That is also connected, arising out of common judgment, Millers. I will turn to that, Millers. But before Millers, I travel to the next point, Millers. So far as this issue is concerned, your lordship found there's two things. One is, Millers, there is gross non-compliance of terms and conditions of the earlier sanction letter, after which bank proposed to reduce the limit, and for that the outcome of the decision was communicated to reduce in phased manner. That was accepted. Now, concealing all those documents from the knowledge of the Honorable Court and by not bringing to record below, because they challenged the subsequent order by virtue of which bank has reduced to 6 crore. That was the challenge, and the Honorable Single Judge Billars, I will not repeat except saying that Honorable Single Judge has not dealt with anything, neither in documents in my counter affidavit, not submissions, Billars, nor any of the decision, nothing, Billars. And in one line, there is not even one sentence of some words observation. They said conclusion, reduction is set aside. But they are a commercial distance. And I'm sorry because Honorable Single Judge directed setting aside the reduction of limit and directing that yes, he is entitled to avail the full loan. That is how Miller's matter has been addressed to us. Now, with your Lord's kind permission, may I proceed to the next? If probably
whatever you say
after lunch, Millers, let it continue.
Yes.
Because I am at the last matter, so I have the advantage of addressing your lordship.
Yes.
There is no other matter. 1 hour still there with my lords.
Yes.
Obliged.
And 3, no? 3.
Friend has submitted that 150 rectification order, that income tax. Your lordship have marked probably disposed of. That they have rectified, so there is no cause of minus. Minus.
So it virtually become infructuous.
Absolutely. matter. Yes.
May I rephrase the entire argument to squeeze it into a very small compass?
Absolutely, yes. That
Your contention is first, when the single bench has framed three questions, then it is the ardent duty of the judge to decide all the three questions by assigning the reasons.
correct.
The first question, which is very pertinent in the issue, when he framed that question, there is no finding which he has returned on that particular first question.
Absolutely correct.
And surreptitiously jumped to the conclusion that this is not proper. The second one, you say that when the parties have agreed to reduce the cash credit limit from 14 crores to 6 crore, later on, if you implement that particular consensual or a consent decision, then later on he cannot unilaterally retract therefrom or resile therefrom and then say that no, this is done illegally, arbitrarily. Thirdly, your point is that so far as the NPA is concerned,
No, one more point is left on first issue, Millards. Yes, my point is, when as per the conditions order, the financial condition, there is erosion of financial condition, sustained 2 years continuous loss, and the statement shows that he has exceeded.
That is, then it will be a boomerang.
Yes.
Go against you. If you have set up a limit,
okay,
how will you permit any of your borrower to exceed that limit? If you have permitted, you cannot take an advantage of that. You have to take steps against the erring official who permitted. So that I believe can't be a ground for that. But the only thing is the last issue which you want to raise is that there is a RBI guidelines which permits how an account can be declared as an NPA. If they have not serviced and there appears to be an apparent default, then in that event there is no difficulty in treating or branding that particular account as an NPA.
Correct.
I think this is primarily the three questions which you wanted to raise. And so far as the first two questions are concerned, I think if we agree with you, subject to what he will argue, then it's a fit case to go for a remand and to hear out the main matter, giving a returning all findings. That's one. There is no fetter on the part of the appellate court to decide it. But why a party will lose a forum in that regard? This is what troubles, nothing more than that, for the purpose of remand. I think you can cite a judgment on that. That's the bone of contention which I believe is there in the.
So far as NPA is concerned, my lords, there is no cause of action available.
Oh, that is a different.
Correct.
They have to demonstrate that this NPA has been done completely in violation of the RBI guidelines. Now, RBI has issued a guidelines and you are bound by those guidelines because it has got a statutory force.
Section 35A, Millards, Banking Regulation Act.
Minors. That's a statutory.
Correct, correct.
So if they say that it is completely done in departure of the guidelines, then certainly the interference would be there. Otherwise, there is no question of any interference. If we decide to remand, then we will make an open remand to decide everything afresh, not a limited remand.
There's one more relevant fact before I switch over to the next issue, Millards. On the very same issue, Millards, the respondent has earlier approached the ombudsman because what sort of complaint can be, Millards, agitated before the ombudsman are there under the ombudsman scheme formulated by the Reserve Bank of India, Millards. Because these are the grievances which are to be, Millards, covered under complaint, and that is how petitioner has approached. That is section 8 of the scheme, Millards, providing for the nature of complaint to be brought, and he has filed, Millards. And that was rejected. Millards, against the rejection order, I find under 14, section 14 of that scheme, Millards, appeal lies before the Deputy Governor, Reserve Bank of India, Millards. He has not filed any appeal there, Millards, even though such a remedy is available. Next, Millards, then he approached this Honorable Court, Millards. This Honorable Court was approached twice. And let me give my how commercial matters things are getting, Millards, complex. Millards, kindly see for a moment, Millards. The single bench on this very issue has earlier, Millards, dismissed the writ petition. My lords may kindly see paragraph 3, Millards. Para 3, next page. Para 3. Mr. Nanda submits the bank is reducing sanctioned limits of credit facility granted to his client. The complaint of his client was rejected on technicality of the scheme. His client has not found remedy neither from the bank nor from opposite partner 4. Opposite partner 4 is the ombudsman, Millards. His client wants to find relief otherwise, and there is direction giving such liberty to his client. Because para 4, by improved communication and so on, so opposite partner 4 itself put the petitioner at liberty to approach any other grievance redressal forum in accordance with the petitioner is entitled to do so. Because again, one more petition that was also dismissed subsequently. I have given the next page, WPC number 17166. Those are same petition, those are tagged along and dismissed. Because then one consumer forum was also approached, Mirrors, on the self-same grievance, and that was rejected by state forum. Now the petitioner himself in the writ petition admitted that the appeal is pending before the NCDRC, National NCDRC, National Commission of Consumer Relations. That is still pending there. So with all this background, the respondent has approached this Honorable Court before the Honorable.
So far as the Consumer Protection Act is concerned, Section 3 or 4 of the Act says it is the Act is not in derogation,
but in addition to other.
addition to. Right. So
They
these are the different where the deficiency of service has been highlighted, and here there is a action which is there. So both are different.
Different. But so far as the reduction of cash credit limit is concerned, this was subject matter of complaint before the ombudsman, and the petitioner has filed a writ petition before this Honorable Court. This Honorable Court dismissed, saying
But
that
the ombudsman says that if you have the forum to raise the grievance, you are at liberty to go there.
liberty to go there.
And
Yes.
the court has said that when the liberty is given, why you are
Correct, correct.
and they perceive this forum as the proper forum. What can be done?
It is my duty to just bring to your Lordship notice how the very same issue travels before different forums and how. Anyway, now, Millards, your Lordship may kindly travel to Millards issue number 2, my Lords. Yes, loss of source of data. Millards, judgment start from page 81, issue number 2. That is running page, Millards, 92 of writ appeal number 966, which my Lordship considered. Huh?
It is 93 of 966. 93, next page, please.
No, page 92.
966, 93 page.
Yes.
Issue number 1 is the reduction of cash credit limit. Issue number 2, my Lords.
Yes.
Whether the classification of the petitioner's cash credit account as a
That's what I said. Then we'll have to show that where is what the RBI guidelines says and how an account can be said to be NPA.
Correct. Whereas here, you also kindly see what is mentioned in the question, Millards. Whether the classification of petitioner's cash credit account as a non-performing asset on 30/12/2024, you also kindly bear in mind the date 30/12/24 was in compliance with applicable guidelines issued by RBI and supported relevant facts. Now, Millards, the account was declared NPA on 30/12/24, Millards. On the very next day, petitioner deposited the shortfall amount, Millards. Immediately after deposit, Millards, on very next date, on 31/12/24, Millards, that was NPA removed, yes, removed. And the writ petition was filed for this Honorable Court, the next writ petition. That is the WPC.
So there was no NPA
Exactly.
on the date of.
Correct.
I understood. That is what you say. So,
and that
so
is
there cannot be a subsisting grievance or a live cause of action.
Correct. And that is the subject matter of writ petition number 5653 of 25, which is tagged along in the common judgment passed by the Honorable.
So, according to you, that has become infraction.
Infraction, yes.
Not have been done.
Exactly. And one more thing your Lordship will find, I have come across, Millards, between the lines, I have seen the writ petition, Millards. the petition respondent has
Word
got
by word, or you say between the lines, so I say word by word.
maybe at times, your lordship knows in the past how a lawyer we have to at times. In the brief, I find regarding withdrawal, nothing is mentioned. Regarding NPA, clumping NPA, it is there. But after deposition is withdrawn, that was not mentioned.
That is what you say. So the document is already, we will record
Exactly.
that those have already been withdrawn.
Exactly. In the counter affidavit,
there was no occasion to go into the intricacies or the
not
nuances of
required.
that
Yes.
action.
Now it is
And
not required.
Could have, if I borrow the expression of Justice Krishna Iyer, nipped in the bud.
Nipped in the bud. Yes. Nip the bud. But Honorable Single Judge had dealt in thirdware as if it's a surviving issue and to be answered, devoted 2-3 paragraphs.
Yes.
That is there. Your Lordship will find at paragraph.
No, I understood. You
Yes.
need not have to take us. Yes.
So now let me go to the next issue, last issue, Last issue is
the most relevant.
Most relevant. Yes. There is no quarrel. Let me place it, then certainly you will also kindly tell. Whether the respondent bank levied and capitalized penal interest in violation of judicial decisions and regulatory directions, and if regulatory direction, if so, whether such action is sustainably law. That's the point, Because so far as capitalization of penal interest is concerned, Honorable Supreme Court said banks are not permitted to capitalize penal interest. That is the law. There is no quarrel. Neither I have any right or this is the.
That
now,
is why I indicated.
Now, Milords, your Lordship may kindly see, so far the writ petition filed is concerned, Milords, my Lords may kindly see para 10 of the writ petition, Milords. Para 10 from WPC 3167, Milords again.
Yes.
That the opposite party bank, by its letter of arrangement, sanction letter dated 13/11/24, reduced the cash payment limit from 14 to 6 without providing. These are not required measures. It is further submitted that OP Bank in its sanction letter 13/11/24 has categorically stated that there will be penal interest which will be compounded monthly. It further submitted when the petitioner obtained the statement of account, shocked and surprised to find that OP number bank has been charging huge amount towards penal interest by capitalizing. Copy of statement of account from 1/4/24 to 10/12/24 is annexed as Annexure 7. He has given some documents to 45 his time minutes. Now you also kindly turn to Annexure 7. That is at page 29. Yes. Good. Yes. Means 29.8. Yes. Yes. Now, interest accrued to each. Let's kindly see interest. 37. Page 37. Yeah. Page 37. DD interest cap etiki 3514, two interest 20 lakhs 80,161.
Where from you reading?
37. Page 37, Millers.
Just one.
That's what DD PNLT stands for penalty interest. PNLT interest में penal interest.
Let us reach to 37.
Minors.
Yes. Which date?
Millers 36/23 date. Description DD PNLT I
3,514
debit, yes. Then next one
14,949 is a.
Then 14,947 entry below DD PNLT interest. But these are all penal interest. The stand of the bank is that
these are, I would say, inconsequential or insignificant in relation to the CC limit.
My lords, absolutely. Your lordship is not on that. Now is this is a third issue, my lords. This is bereft of that, my lords.
Only those amounts of 14,000, 3,000.
No, more is there. In the
1.22 crore has been debited.
No. It's not that. I would
So
state
just,
I was really
all
wondering
it has
because
been full through an expression. That is the
small,
problem.
No.
There is a statement.
insignificant amount.
Is well written common judgment.
Where is the hefty amount
56.
you have charged
Yes.
and capitalize the interest, penal interest?
Penal interest, yes. Debit,
Page 32.
How much?
Page 32, 3,14,000. Same page, 1,19,000. Page 33, 3,62,000. 9,000, 7,87,000.
Oh, yes.
Everywhere.
Because these are there. So our stand is, particularly my lords may kindly see, as per para
capitalized.
Just a minute.
Penal interest
As
capitalized.
per para 10, it is for 1/4/24 to 10/12/24. Now let us see the statement from 1/4.
Typo error, Miller.
Just a minute.
22.
Just a minute. 1/4/24.
22. That's what I meant. 22. That's my mistake.
You have 1/4/24 to 30.
10/12.
10/12/24.
It says a typographical mistake, but Annexure 7 runs from 2022.
That's a typo error of 2022.
Anyway,
That's what I meant. It runs
So-
from 2022.
Correct. Now the stand of the petitioner mirrors that we debit penal interest because those are debited in either mirrors interest simpliciter or it penal.
No, it has to be debited from
Absolutely. And so far as penal interest is concerned, there is no denying the fact that bank don't have the power to levy penalty. That is also
you'll have to reverse.
no. You also kindly try to bear with. Penal interest is an interest which is to be levied. There is no quarrel over this also. The grievance of the respondent is you cannot capitalize this. We say we are not capitalizing as per RBI circular bills. I will show to lots of RBI circular.
Once you capitalize it, then the other common interest will attract over it.
Exactly correct. That's right. Okay, that's right. So therefore, what we have done is we have debited the account, and penal interest is chargeable interest as per agreement, as per circular, as per RBI guideline. We have to impose penal interest if there is default. Those are there. That is also not. There is no quarrel over this by the respondent.
Yes,
But
I have objection.
just a minute.
You show some document.
No. Probably let me repeat my.
You will get an opportunity, sir.
Let me repeat my submission for the purpose of clarification. Respondent has no quarrel over imposition of penal interest, except that what he quarrels is that penal interest, even though imposable, cannot be capitalized. And for that, relies upon judgment in the case of Ravindran, of this Honorable Apex Court. Our stand is that so far as penal interest question is concerned, we could not have also quarrel with the decision that is binding on us, number one. Number two, Honorable Single Judge and also in the plaintiff, they have claimed that they have to follow the RBI guidelines. Milords, as my lords knows, all banks function under the guidelines given by the Supreme RBI under 35A Milords.
Yes.
And there is a guideline which I have annexed to the writ petition, which your lordship will find with the annexed report. That guideline.
In a counter file before that trial court, you have annexed?
Yes.
Where is that?
That your lordship will find. Hello. Guideline are there. No? Guideline the Supreme Court दोनों का ना RBI दोनों का हाँ
I do not find.
ये तो अनेक्स ही नहीं लेकिन वो तो कभी फिर counter
Counter affidavit, flagger.
The counter it was not there.
In the second next counter Arata
31627.
कूट अच्छी में देखो ना
Guidelines is not enclosed.
So guidelines are not
पूछ
enclosed.
नहीं इसे तो कौन पूछ This is prospective eligibility. Let's may I pass on one with my lord's kind permission.
You are in appeal, sir.
My lord, this is
Whatever the documents, if you want to rely, this is not a citation.
my lords, correct.
So
Then my lords may kindly see, my lords, the note of submission I have quoted. My lords may kindly see.
can you argue something? Divorce the
Dears the record, my
pleading.
lords. I understand, my lord. Your lordship is quite correct in saying so, my lords.
So
Now, your lordship may kindly see my submission, which starts from page 58, my lords.
Of
58 of my lords, the writ appeal. Writ appeal.
966. 58 of the rate appeal.
Minus 966, that is the one. Continue. Page 58. Put the
Yes.
అంటే I have seen somewhere. Oof. Perspective from aged. Huh? Huh? No, no, actually I have shown somewhere. Huh? Written note कहीं देखो ना जी.
Petition, the secondary petition which I had filed, there at page 54, the circular is there in my writ petition. The secondary petition.
That is also, yes.
My lord.
The guideline there. No, he didn't.
Master sir.
This is not that one. No, no.
Master sir.
That's what I did. You know, you have taken point, but only what happens. You don't know the solution of the day. You also got to follow very Yes, I'm so sorry. Somehow it has not been mentioned. We are stated for this. But if there are penalties and shall not live in proper. Just I'm reading with my lord's permission. I am may not be. I am still trying to find out penalty if charged for non-compliance of material terms and conditions of loan contract by borrower shall be treated as penal charges and shall not be levied in the form of penal interest that is added to the rate of interest charged on the advances. There should be no capitalization of penal charges. That is no further interest computed on the on such charges. However, this will not affect normal procedure for compounding interest in a loan account. So, interest in respect of loan account, that can be compounded, but so far as penal interest is concerned, that cannot be compounded. That can only be charged. And this notification of RBI is prospective in nature, that is with effect from 1/1/24 minutes. As per the still let us find out. So my humble submission before Lordship is so far as the pleadings available arising out of retribution concern, because it is for a limited period, and I have specifically mentioned for that period, as we have verified as per the RBI guideline. Somewhere I'm sorry, let me try to still find out, Mirrors. As per RBI guideline, Mirrors, it has not been capitalized. But for the period, entire period, if my lords will ask me at all to verify, those are still to verify. That is why you have stated that, because it's a matter of disputed facts, which can only be revealed after verification of the past records, because all the transactions are to be verified in detail, Mirrors. But so far as the RBI circular, which is valid from 1/1/24 is concerned, that onwards we have scrupulously avoided and no capitalization at all, Mirrors. Prior to that, we have to verify. This is a matter of so that is the only thing, Mirrors. So far as capitalization is concerned, we have followed RBI circular, and after receipt of RBI circular, Mirrors, we have complied with that statement. We can make, Mirrors, clear statement. We can.
Difficulty is that Section 78 of the Indian Evidence,
My lords,
unless you bring, that's the whole difficult.
Milord, still I am trying. I understand. I am very grateful to your lordship to bear with Milord. Somehow I have a strong impression. Must be able
we dispensed with many provisions of the Indian Evidence Act. We do not also take into account Section 84 also.
It cannot be, Milord. I think something necessary, inevitable for considering an issue. Your lordship may have the discretion to entertain. Milord, subject to maybe not so. Section 151
of any additional evidence, need to produce some documents
in the spirit of 151. Something
order 41, rule
order
27.
Additional evidence.
Order 41, rule 27.
Additional.
Look at section 78. You can definitely do it.
Other appeal, the following public documents are proved as follows. So, other notifications, even department.
You did not have to prove, but those are to be
by the record. Department certified with the department Remand, so and so. Additional. Yes.
RBI
may be proved. So,
no, not required to be proved. There is already, but has to be brought on record.
Brought on record.
And nobody cares. Even nowadays, Section 84. For some other reason, you just turn the page. Section 84.
Presumption as to collections of laws and reports of decisions. It shall presume genuineness of every book or to printed or published under the authority of government of the country and to contain and of every purport. So presumption is there.
Can you cite SCC or let us mute?
There in the record by me and the writ petition, the second writ petition, the circular is already there in the record.
Oh, this circular which is
Yes.
relying on,
Yes, yes.
then it is a part of the record. No difficulty. Show us.
5653, page
Oh,
54.
then there is no difficulty.
Annexure P4.
Oh, then
Okay. P4. 53?
Yeah, that is.
Page 54.
Yes.
No, this notification is dated, master circular dated 1/7/2009. But the circular which I am referring is 18/8/23.
That is
This
capitalization of interest. That
This
is
is not capitalization of
different.
interest.
That is different.
That is a master circular.
No, the judgment, my lord, passed by the honorable single judge
if it
based
is
on
not
this.
there, then you can.
It is not there, yes.
That is on the different issue and this is on different
Exactly,
So whatever.
Yes, yes. Both issues are there.
In the midst of an argument, Mr. Saud, and I'm a senior advocate, intends to rely upon the circulars. You give an objection when the document comes.
Well, not today. Yes, yes.
We have not granted any
Yes.
liberty. We simply adjourn it.
My apologies.
Such and such.
Interim want to continue because it was there till next date of listing up to today only.
To continue till the next.
Any date?
So you go through that. These are the
Any date?
documents which are public documents, which are undeniable documents. It's there on the portal. So if the only thing is the interpretation, whether it has got any bearing on a point which is agitating.
Correct.
So all these things you have to go through.
Then, Miller, the judgment cannot be held wrong because the document was not produced before the honorable single judge.
That is what I am saying.
My lord.
Then the provision of Order 41, Rule 27 has to be deleted.
My lord.
If every time the judgment cannot be impeached, then the appellate court should not admit the additional evidence. It is only because of that. We will not say the judgment is wrong. We will say that this document has a bearing.
So since it was not before the honorable single judge,
no difference.
Oblige.
Item number 1.
I plead your lordship. That's in non-compliance of the order passed by the Supreme Court.
Where is the original order?
Order, your lordship, at page 10. It's starts from.
Where is the operative portion of the
operative portion is lordship here. Paragraph 5 at page 10.
Just one.
Opposite part number 5.
Just one. Let me hurriedly go through it.
Yes, sir.
Yes. So in a contempt jurisdiction, it is a matter between a court and the contemnor.
Yes,
You are simply an informer.
Yes, Your
Don't worry. Yes, there was a direction.
Yes, I have gone through.
That you'll have to do it within a period of 2 months. First thing I wanted to know whether the order says that the petitioner will obtain and serve the certified copy of this order on the opposite party number 5. Show us the service of the copy, the certified copy of this order.
Lordship, I made a
Where is that?
averment in my petition.
Where you
page
have said
3
so?
on 1. Lordship,
Which paragraph, sir?
paragraph 3.
3.
Yes. That the petitioner had forthwith communicated the certified copy of this order along with all the annexure
Where
appended.
is the proof of service?
I personally met the collector.
Do you have any receipt or a
They are not
seal which
they are
have?
not giving this
Did you
receipt.
write any letter to them?
No,
Did
no,
you write
no,
any letter to
no, no. I myself have filed this affidavit by
No,
way
I
of affidavit.
understand when you are appearing in person, you will definitely say, but the law will take its own course.
Yes, yes.
It does not get changed from
Yes,
the perspective of the person appearing in person and the
on
representative
1/8/2023.
Now, what is, have you received the copy of the certified copy?
That's what I was talking to my friend just
Yes.
before your lordship came. That I may be granted 15 days time as at a maximum. I'll try to see that the order is complied with, provided he has given the certified copy as per his averment in the petition. Because there is no document
Proof.
to.
No proof regarding service of
Yes.
certified copy and other
If
documents.
at all my learned friend has given a copy of the judgment along with that letter, certainly I'll try to see that within 15 days it will be complied with, because it is a.
No, that is a different. But here we are concerned with the contempt jurisdiction.
Yes, my lord. I'm conscious of that.
And we are not really dealing with the original petition.
Yes, my lord.
So only thing is the period of 2 months will reckon from the date when he
Submitted.
sends over the certified copy of the order.
Yes,
So that is the main question when it has been served.
1/8/2023.
Correct. So now,
paragraph 4.
now you'll have to either deal with this or now you have got a certified copy because it is now annexed to the petition.
Yes, copy of the order has been annexed to the petition. Service, there is no.
So you'll have to file you have to file your affidavit.
I'll file
You
my
have to deal with the allegations.
Yes,
because whatever it's a quasi criminal, so you are liable to be punished under the Contempt of Courts Act.
I'm concerned.
Then you are entitled to defend.
Yes.
Constitution says nobody can be punished without being hurt. You have an opportunity. So file your affidavit. Stop. By What date? Who is the contempt? Correct. Give. Collector.
Commissioner should direct.
Not commissioner, but the collector was
Yes,
the
collector.
Yes.
Opposite part number
So
five,
we correct the order.
Yes, yes.
I have dictated commissioner.
Commissioner,
So it's the
Commissioner
collector.
I'm
is
trying
to
to
make the requisition.
Correct.
But commissioner has not been added as co-contemptor.
No, no.
The
No, he has
commissioner
not
should
been
have
added.
been, because
He
the
has not.
commissioner was also directed to
Yes.
take steps to follow up the
Follow the prior to that
those
he,
should have been added. But you have only
but the collector has been
initiated
directed.
contempt proceeding against the collector.
Let's see collector. Yes, collector is to execute. Section 68(3) says so.
Why you use the word contemner?
That is
Unless-
my practice since.
Unless the person is found guilty, he can't be said
It
to
can
be
be
a
said
contemptor.
opposite
That's
party.
why I have used the word alleged contempt.
alleged contempt. not absolute
Oblige,
same.
oblige, 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 Your Honor.
Always there the pleading is alleged contempt.
Alleged contempt. That happened. My land friend is also an advocate, practicing lawyer here.
The rules framed by the High Court
Yes,
relating to the contempt.
we are generally filing.
Then in that event, you'll have to specify the act of
Yes,
the
section
contempt
Yes.
in the preamble.
section
Yes.
12.
You have not included
yes,
even an act of contempt in the prayer,
yes.
Should have been.
that he should be punished for
Alleged.
willful and deliberate violation
violation.
of these.
Well, that's if this is my practice, so that
You are a practitioner, that's why we are saying.
I'm
Had
changing.
it been a common man, we would have.
I am changing.
Since you are a legal practitioner, that's why we react.
Yes, Your Honor.
No,
Yes.
can't.
I'm obliged.
Date, my lord, it will become
8th August. 8th
8th August.
8th August. I'm obliged.